Sunday afternoon. We normally start with a prayer, and Father Jerry tries to come and lead us in prayer. We're going to say a little prayer at the end. And right now, I'll just say, say a quiet prayer. Say a quiet prayer to yourselves for Father Jerry. If you weren't here this morning, you know that you wouldn't know that he fainted and fell at the 9 o'clock Mass. So he is okay, but he is at home resting. So just say a little prayer in your hearts for his speedy recovery. And we're going to get started. Welcome. Thank you all for coming. This is the last program of our year. And I'm going to talk about that at the end, and then we'll have a little prayer at the end. And I'm going to let our speakers introduce themselves because they do a better job than I do.
Thank you. Good afternoon. Thank you, everybody, for coming. It's so good to see so many familiar faces here today. I think this is my third year speaking to St. John's, so I'm very happy to be back, and I'm very happy to have my good colleague and friend Dario Cavazos here with me today. We're going to talk to you about a topic. I think probably both of us get a lot of questions from our clients about how to avoid probate. And I hear a lot of confusion among my clients and other people about what probate is and why they should be so worried about avoiding it. So we're going to kind of tag team the presentation instead of having one person ramble on and then pass the mic to the other person. I think as we cover different topics, you can hear from me. Oh, I guess you want to know who I am and why you would ever want to hear from me. I'm an elder law attorney. Elder law is all I've ever practiced for 12 and a half years now. I don't do any other type of law. I have a small practice on Main Street in Sykesville, which is how I recognize so many of you. And I also have an office in Frederick, which is how I started doing some work with Dario, so he and I share several clients as well. You know, elder law as opposed to estate planning, just to differentiate the two, I guess you could say I started out doing estate planning work, but early on began to recognize a need and had more questions from my clients, not just about the planning documents on the front end, but how they're used and how they're implemented. Started to get more questions from clients about how the documents would be used later on, and then their children would come to me if they're in the event of illness or death, and then I would help the children use those documents. And that kind of presents a whole different set of issues. So not just the pre-planning, but actually in the implementation of that plan later in life with an eye toward how to protect assets in the event of long-term care, from taxes, and from probate, which is what we'll be talking about today. I'll let Dario introduce himself while I try to get my slides pulled up, and then we'll get started.
Awesome, thank you. So Dario Cavazos with Edward Jones. I've been with the firm for about 12 years now, and it's an awesome pleasure. Oh, sorry, just one mic? Okay.
Oh, you have your mic on. I
yep.
forgot. I'm sorry.
Oh, okay.
Oh, I'm sorry.
Good. I don't have to hold a mic. Can you hear me all right back there? Okay, fantastic. So I started my business in Frederick, Maryland. I've lived there for about 15 years. I know I look young, so thank you. I appreciate it. But my wife and I have 2 boys, and we live in Iamsville, which is near Newmarket. So being with the firm for about 12 years, what happens a lot of the times is we get a lot of questions from our clients. And I think one of the things that's really important is making sure that you're prepared for the unexpected, right? So how many folks in the room have a will?
Oh, that's a great number.
Excellent. Okay. How many of you know how it works? and then where is it at? That's the other question. Yeah, exactly. So I think we'll cover a couple of those topics today. My why and why I'm here today is because I think we can do a better job of explaining how things work, and then if you have questions, we'll help guide you through that. But Shannon has had a great partnership with the firm for almost about 5 years now and building her practice in Frederick. We believe in partnering with other professionals. So how many of you are using CPAs as well? Right? Okay, yeah, excellent. So that's a team. That's a team that we like to work with. So we keep that independent. Thank you for being here, and we'll talk a little bit more about how we can help.
Okay. Yeah. Now, hold on. Now you're getting into all of the good stuff. That's because I was sitting there clicking that button for so long, waiting for the slide to come up. Okay, so we're going to talk to you today, like I said, about avoiding probate. So I think the best place to begin when we're talking about how to avoid something is even understanding what it is you're trying to avoid. So this is what I ask people when they come in and say, my main goal is to avoid probate. And then I say, well, tell me about what probate is and why you want to avoid it. And then there's a long blank stare. So let's talk about what exactly probate is. For starters, it's really nothing to be afraid of, okay? Probate is an administrative process, for the most part, in Maryland. We do have something called judicial probate if there are certain contested issues within your estate. Let's say one of your beneficiaries tries to argue that your will is not valid, or you've attempted to disinherit a spouse. Those would be issues that could give rise to judicial probate, but for the most part, it's an administrative process which I conduct entirely from behind my desk and behind my computer screen. So if there is a probate process, I fill out some forms, you assign them, we mail them in, they send me something back. That goes on for 6 to 9 months, and then usually the whole thing is over with. Probate does not automatically mean, even though I just said 6 to 9 months, that none of your beneficiaries will get any money until the end of that 6-month period. That really all depends on the circumstances, creditors, other issues that might involve your estate. But suffice it to say, it is an administrative process. And it's a process that, as it says, before the Register of Wills, which is an office within the circuit court in each county. So every county has their own Register of Wills office. If you have filed your will for safekeeping in the county in which you reside, that would be held with the Register of Wills office. And then when you pass away, the will gets withdrawn from safekeeping and then it gets filed for probate, which is when it becomes public record. And so probate is the process of transferring assets out of your name, we're going to pretend like you are the decedent, out of your name alone at your date of death and into the names of your legatees or heirs, beneficiaries, all depending on the documents that you have. Okay, so only the things left in your name alone. Any asset that has a surviving joint owner is not a probate asset, because when you pass away, ownership passes automatically to the surviving joint owner. So it doesn't need to go through probate. Any asset that you own that has a designated beneficiary, like life insurance, retirement accounts, those are typical examples, those usually pass outside of probate to your designated beneficiaries. So when the transfer of ownership happens automatically by some other process, survivorship, beneficiary designation, then those things are not probate assets. So probate is just the process where when you're left holding the bag, there has to be a way to transfer that title to the names of your beneficiaries, and that's what probate is. So another question people ask me is, well, so does a will help me avoid probate? And the answer to that is no. A will actually controls what happens within your probate estate, and only your probate estate. Okay, so if you do have a retirement account with designated beneficiaries, let's say directly to your children, your will does not control that retirement account. Okay, your will only controls your probate assets. So it doesn't help you avoid probate, it dictates what happens to the assets that are going through probate. And if you die without a will in Maryland, then those assets that are left in your name alone will pass to the beneficiaries as named by the law in the state of Maryland. That's where you hear about intestacy or intestate succession. Those are the statutes that define who your beneficiaries will be if you don't have a will. So that's one of the most important reasons to have a will, so that you can identify who those beneficiaries are. Do you want to say anything at this point about designated beneficiaries?
Yeah, absolutely. So how many of you have TODs on your accounts? Does that sound familiar? Yep. Okay.
TOD,
Yeah.
a transfer on death?
Transfer on death. Okay. Yeah. So that's one thing. And then at the bank, it can be a POD. I think it's important to remember that a lot of the ladies in here, please do not add your boyfriends as a beneficiary on that account. Because what could happen is like I say, that money can go where it's supposed to go. So when we receive a document in the office that has a transfer on death, as soon as the beneficiary brings the death certificate, that engages our firm to start to distribute assets. So how many of you reviewed them recently? Are they where you want them to go? Yeah, okay. So it's always good to just review those 1 to every 3 years so that you know exactly where it's going. How many of you have children that haven't repaid you a loan? Right? So you might want to think about what your percentage is, but I think that's a faster way to get assets to the beneficiaries that you've stated, but I would suggest that you review them every once in a while just to make sure, right? Does that make sense for everybody? Yeah? Okay, so just continue to do that and make sure that you talk with Shannon, because sometimes we get clients who forget that they have things out there, and it happens a lot. So I think it's important that you make sure you understand where it's going and how much is going to, okay?
I agree with that point, and I often remind my clients after they've executed their will and after they understand that this will only controls the assets in your name alone. So if you want all of your assets to pass outside of probate, but you want that distribution to be consistent with what your will says, then you need to make sure your beneficiaries under your accounts match the beneficiaries that you've named in your will. Now, another possibility could be that you intentionally make those things inconsistent. So maybe you have everything in your probate estate goes 50-50 to your 2 kids after your spouse passes, but maybe you have a friend or another family member or a charity or something like that that you want to designate for a specific account. As long as you're doing that on purpose and not unintentionally, then that's fine. But every 1 to 3 years, you should be reviewing your estate plan, you should be reviewing your beneficiary designations. Another fun fact that I see not infrequently is when people get divorced and they fail to remove their ex-spouse as a beneficiary. So Maryland law says that if you forget to come back to see me to update your will, and your will says everything goes to your now ex-spouse, that will not be binding on your estate. So it will automatically disinherit that person that is now your ex-spouse. The same is not true for beneficiary designations. So I've had clients call me and say, my ex-wife just passed away and I'm still the beneficiary on her $500,000 retirement account. This must be a mistake. And it might be a mistake, but by law, that money does belong to that beneficiary. So those are good reasons to revisit your beneficiaries, make sure that they match what your will says, or they remove somebody who has passed away or from whom you are now divorced. You want to make sure that those are current reflections of your wishes.
Yeah, good point.
So if a will doesn't help you avoid probate, what is so important about a will? Well, like I just said, it's really the only way to be sure that your probate property passes as you intend for it to pass. So you might be able to go through your complete list of accounts and designate POD, TOD, beneficiaries, joint owners on everything that you have. One of the most common probate assets is the house when the second spouse dies. So for many people, that's a very valuable piece of their overall estate. So you want to be clear in your will about how the proceeds from that house will be divided among your family members. Another important reason to have a will is it allows you to make the choice about who will be the executor, personal representative of your estate. Who do you trust to execute your will? And you know, if you have minor children, you would also be choosing who would be the guardian of those children if both parents were to pass away and the child is still a minor. If you have a trust within your will, then it would also designate the trustee, how the money will be managed within that trust after your death. And as I said a moment ago, you know, I think of a will as a safety net in some ways. So my goal is also to have as many things pass outside of probate directly to your beneficiaries as possible. But if anything falls through the cracks, we still want to have that will there that says it also goes 50-50 or to your spouse entirely, whatever you intend for your estate distribution to look like. So speaking of spouses, and I mentioned what happens when you get divorced and the beneficiary designation still takes effect. It's also interesting to know that you cannot disinherit a spouse in Maryland under your will. Spouses are entitled to a minimum share of your estate. So even if your will says, I leave nothing to my spouse, your spouse, upon your death, has the right to say, no, I'm going to take my elective share, my minimum share of your estate. I'm going to override your will. And depending on the other family members involved in the probate process, on whether or not there are minor children or children at all, that will affect the share of the surviving spouse. So that actually becomes not so much about just disinheriting your spouse because you're mean-spirited, I guess, but that's an important tool that I use in long-term care planning all of the time. So if I'm trying to protect assets for a spouse who's at home, and I have another spouse in a nursing home now receiving Medicaid benefits, I want to disinherit the Medicaid spouse. In the event that my spouse at home dies first, and we've just shifted all of these assets and the home and everything into the name of the community spouse, is what we call them, if that person passes away first, I do not want all of that money to go back to the spouse who's now receiving Medicaid, because then they would lose their benefits, and then that money would be exposed to payback to the state of Maryland. So there are legitimate reasons for disinheriting a spouse. But when we need to do that, we do that through beneficiary designation, because we know we cannot disinherit the spouse through the will. Okay? Anything to say about disinheriting?
Yeah, no, I think when we come to this part of the spouse, when you change a beneficiary, how many of you changed beneficiaries recently? Oh, that's a good thing. You love each other. I love it. This is good. But yeah, so you,
We're going to change.
yeah.
Soon, because we're changing our IRAs to another account. But then
Yeah.
there's something called extirpates.
Per stirpies.
Per stirpies, yeah,
Yeah.
yeah. So I think that's important, and one of the things that the firm does not take lightly is when somebody changes their beneficiary. So we have to have those documents signed and witnessed so that they make sure that they understand what they're signing, because sometimes you can by accident place a different beneficiary on there, or you maybe did equal percent, or maybe not a percentage that you chose to do. So it's important that you make sure you do your beneficiary designations the way you want them to be executed, because sometimes we do see in our office where the money went to the wrong person. And it happens, but they were with assets from a different company. Mm-hmm.
I may not understand this whole concept correctly. For example, if I have a house, my husband is in the nursing home, it's Medicaid. My house would be in the will, you know, it would say go to him first, I die first. So, and if I die, how can I override this will by making him a beneficiary? You know what I mean?
I do know what you mean. So the question is, if the house is jointly titled right now, but if your husband is in the nursing home and he's on Medicaid, and if you die first, that your will says everything goes to him, how do you override that? Okay. So we would do that through a deed, a very specific type of deed. So the same idea as adding a joint owner to a bank account, we can change the title to your home so that ownership passes automatically upon your death to, it's called a remainderman, but it's really the same as a beneficiary. It's an entirely different legal document only for real property. Yes, those are the types of planning techniques that you should never venture to do on your own, because if you do the wrong thing, you could really mess it up. But there are opportunities there to protect your home from a Medicaid lien or from going back to a spouse that's on Medicaid. That's exactly right. The question was that we would do that type of planning to make sure that the surviving spouse's benefits are preserved and the assets passed to the children. That's correct.
Good question.
There was something you were just saying about...
The beneficiaries.
Yeah, we were talking about beneficiaries and spouses. Oh, per stirpies. I wanted to get back to that. That's a good question. So you may not have noticed, but if you go back and read your will, I guarantee the Latin phrase per stirpies appears in your will somewhere. That's two words, per, P-E-R, and then S-T-I-R-P-E-S, per stirpies. Generally, the concept of per stirpies means, let's say that you have two children, and child A has two children, and child B has no children. And at the time of your death, child A has predeceased you. And so your surviving descendants include your child B and then child A's children. Per stirpes means that only child A's share passes down to their surviving children. So they would each take 25%, child B would still keep his or her 50%. That's what per stirpes means. That's an example of how it works. The alternative to per stirpes would be per capita distribution. So under that same scenario, per capita would mean the entire estate would be reallocated equally among all of the survivors. So basically child B would be penalized because their share would be reduced to 33%, equal with A's surviving children. So that's the idea of per stirpes, is that it's only passing the share of the deceased child down to that child's descendants. It does not affect the share of the survivors. Does that answer your question? That's a good question.
Yes, I still want to follow. So the document from the investment from the says, and it will be governed by Maryland law.
I assume that means...
Yeah, so we have to default. So some firms will follow those laws that are in place, right? But in our forms, it's going to refer either whether you chose that or whether it's the default. So, yeah, okay. So a lot of the forms that you'll see are sometimes just confusing, and a lot of the language that's inside of it.
But like, so if one child doesn't have any children, but he has a spouse, then the spouse would get that.
Not usually. The question is, if one child doesn't have any children, but they have a surviving spouse, would that child's share go to the surviving spouse? Under Maryland laws, no. I don't think under policies of any account that I've ever seen would it go to the spouse.
No.
It's pretty uncommon. I would say less than 2% of my clients over the time I've been practicing leave money to a child's spouse. It almost always stays within the lineal descendants.
And you would have to designate that if, has anybody heard of a contingent beneficiary? Okay, so a contingent beneficiary is just based on the passing of the first person. So if you left it to your son, per se, and your son passed away, you could then take that share, and the contingent beneficiary to him would be the spouse. You would have to designate that if that's what you chose to do. So she better be nice to you. No.
And one last point maybe about the fine print on some of those beneficiary designation forms. There's usually some language that explains what happens if there's a complete failure of all beneficiaries. So if you have no surviving, and this is the importance of designating contingent or constantly updating your beneficiaries. If your primary beneficiary passes away, you might want to bump your contingents up and then name new contingent beneficiaries. Because sometimes if all of your beneficiaries have died before you, that could end up, well, depending on the terms of the account, that money could come into your probate estate. Sometimes it will be paid over to the estate of, and then we go and have to open an estate, and that money gets tied up in probate for the next 9 months.
Yeah.
Whereas it could easily avoid probate if you keep those beneficiaries constantly updated.
Let me share a quick story with you, and hopefully this will help resonate or exemplify what she's talking about. So we had a client who was a great guy. He had no spouse. He just had a girlfriend that he lived with, and he owned some property. And his mother, who was about 89, she's an awesome lady. She still has all of her mental capacity. But we were having a meeting, the both of them, and they came in, and a couple days later I get a phone call. And the phone call was that her son passed away, right? She never thought that that was ever going to happen. And so now she has to go through probate. We don't know what his beneficiaries were, but he had multiple assets across different firms and 401ks, etc. So now his mother has to go through this whole process. Thank God, you know, we work with her, and we've worked with that family for 10, 12 years since I first started, but there were no beneficiary designations. Now she has to come into the office, and we have to go through probate. And she's 89. She doesn't want to go through this. But if he would have just taken a couple simple steps to name a beneficiary and then contingent beneficiaries, now the girlfriend, who's an awesome lady, might not have a home to live in because she might have to sell that house. So better planning could have done a couple things differently, but those things happen unexpectedly. Just prepare for those things, just in case, right? So it's important to remember.
So how can you avoid probate? If that's our goal here, let me make sure I covered this. So if our goal is to avoid probate, to simplify the transition of assets or the passing of your wealth on to your spouse or to your children, what are the ways that we can do that? Well, I've mentioned joint ownership, and I'll just say a word of caution. I think when I was here last year, I talked at length about this particular issue. I generally advise, and I feel comfortable generally giving you all a free piece of legal advice here today, not to name your children as joint owners on your bank account, okay? People do it all the time, so don't feel bad if you've already done it. I've heard bank tellers advising their customers to add their children as joint owners on the account. They just don't know what the consequences are by telling them to do that. So when you own property jointly with a spouse in Maryland, that property has certain protections against creditors of either spouse individually. Okay, so property owned as tenants by the entirety between spouses in Maryland is protected from the creditors, the individual creditors of each spouse. The same is not true when you add a child to your account. So let me give you a couple reasons why, and we're going to pretend like there's a family with 3 children, and you've gone and named your oldest child as the joint owner on all of your bank accounts, and you come in and you proudly tell me that you've done this because it will be so much easier if something happens to you for that child to pay your bills. That part is true. However, because they are now a joint owner, they have as much ownership and right and access to the money in that account as you do. So taking a standard checking account, for example, that child could withdraw every penny in that account and use it for whatever they wanted to without your knowledge, without your permission. And you would be hard-pressed to argue that you didn't really intend for them to be able to do that because you put them on as a joint owner. So even if you have a child that would never do such a thing, if that same child is in a car accident or gets divorced or is sued, your assets are now exposed to that child's creditors and liabilities. So that same asset protection that exists between spouses does not extend to children. Let's take it a step further and say that you have a will that says all of my money goes equally to my 3 kids. But when you die, ownership of that account passes to the surviving joint child. It's not controlled by your will. So that's what I meant earlier about when you revisit your will, you revisit your beneficiary designations. Sometimes people make those inconsistencies on purpose, sometimes they don't. So a lot of clients say, why do you need all of this information when I'm here for my will and I'm asking for account numbers and how accounts are titled? Because I want to see if you have one of your 4 children named as a joint owner on your accounts, because that's going to throw off the distribution of your entire estate. And then the last point, as if that's not enough good reasons not to do that, if that child is good enough to turn around and say, I know my mom really intended for me to share this money with my siblings, so I'm going to give them their 1/4 each of the balance in this account. That transfer from the surviving owner child to their siblings has potential gift tax consequences. So when you talk about annual gift tax exclusion amounts, I mean, it all depends on the balance in the account, but that's a gift from one sibling to another. Whereas if those children had inherited that money directly as POD or TOD beneficiaries, or even through probate, none of those tax consequences apply. Okay, so there's 4 or 5 good reasons not to name a child as a joint owner on your bank account. If you want them to have control of your money while you're alive, or not control, but to help you pay bills if something happens to you, you put your power of attorney on the bank account. That's why you should have a power of attorney. That gives them all of the access, all of the fiduciary powers. So then they're required to act in your best interest. They can't take all of that money and run off with it. They would have criminal and civil liability if they did so. They are required to use the money only for your benefit, to pay your bills, and then if you want to keep the money out of probate, you put all 4 children as equal POD or TOD beneficiaries on the account. So you accomplish the same thing, access and avoiding probate, by remembering POA, POD. That's all you have to remember, POA, POD. not joint account ownership with a child.
Yeah.
Okay? Yes? POD is payable on death. TOD is transfer on death. I think the only difference is the type of asset that's held within the account. So I think if it's like a securities type of account, it would be a transfer. If it's a bank account, checking account would be payable on death.
Most of the banks will do POD.
With a power of attorney. So she could say, you can accomplish the same thing, but only with using a power of attorney document. Yes.
Yeah. And so one thing I'd like to add is that we have seen clients, you know, and their children, you have a loving sister, but, you know, they spend a little money. One time we had somebody go out to Las Vegas and take $10,000 out, and this was the daughter that they thought was, so if I see you at the casinos, I'll know where it came from. But it's happened, you know, and that happens all. We don't think that it does, but I promise you, money changes everybody. We get to see it all the time. It does. So another thing that she had mentioned also is that the power of attorney. So whenever somebody withdraws money from the firm or their accounts at our firm, the branch office administrator has to designate who requested the money. Because our firm does not take that lightly either, where if somebody sees a recurring withdrawal or there's some tendencies, they're looking at your account to make sure that somebody's not taking advantage of you either. So our compliance department is constantly monitoring who's taking the money. So there's a little radio button on our accounts that says POA took money, not the client. So that's something that you want to make sure you share with your financial institutions, that they're watching that, okay? Safeguarding your money.
Can you have more than one POA on a parent's account in the bill?
The power of attorney, the question was, can you have more than one POA designated on a given account? The answer would be within the document itself. So in your parent's power of attorney, it would say maybe you're the primary agent, but if you're unable or unwilling to serve, then you have an alternate agent and then maybe a second alternate agent. So adding a POA to the account doesn't necessarily mean adding your name. It means adding the document that the bank has recognized that the account owner has given authority to these other people named in the document to manage that account for them.
Mm-hmm. Yeah, good question.
I think we've painted joint ownership with a pretty broad stroke here as being a bad thing overall. I don't want you to leave with only that thought. The other point I want to make about it, and the reason I look at how the accounts are titled, sometimes people just accumulate these miscellaneous accounts or CDs that they forgot they had opened, and they went to the bank to close a checking account, and then they sold them on a CD with a good promotional rate, and so they signed up and they forgot they never put their spouse's name on the account. So anything like that between spouses, individually titled accounts, it's a good idea to go through that list and make sure if there's a reason you don't want your spouse as a joint owner, that's fine, but then you would want to make sure they're designated as a beneficiary. But if there is no objection to naming your spouse as a joint owner, it's a good idea to make sure that those things are jointly titled. Because the goal is always to try to avoid probate altogether when the first spouse dies. You don't want your house or your car or your checking account getting tied up in a probate process when that's been your regular bank account for years. You just never realized your name wasn't on it. So make sure that your marital property is titled jointly for the convenience of the surviving spouse. We've also talked about another way of avoiding probate is making sure that your beneficiary designations are up to date, that they are consistent with your will, which is your safety net. And the last point I'd like to mention, and we're going to talk about this for a couple minutes, is the idea of a trust and how a trust also avoids probate. Do you have anything you want to say before we talk about trust?
No.
Okay.
That's great.
So remember, the point here is if the deceased person has nothing left in their name at the time of their death, then there is no probate. Everything passed automatically through one of these other vehicles. So what is a trust? A trust starts with a document. It's a legal document drafted by an attorney. And we're talking today about a vanilla, run-of-the-mill, revocable living trust. This is the trust that if your friends tell you you have to have a trust, they're talking about this kind of trust. When Susie Orman tells you you have to have a trust, she's talking about this type of trust. I will say with an asterisk that I'm not a huge fan of these trusts, kind of for the same reason as when people say I have to avoid probate. Most of the time people don't know why they're asking for a trust, except that somebody else told them that they need one. But it is important to understand that a trust can help you avoid probate. That's probably the one thing that a trust does really effectively. So the point I tried to make before we got to the topic of trust was probate is not the end of the world. So if if you do have assets that have to go through probate, it is not the end of the world. But if you would like to avoid it at all costs, then a trust might be the way to do that. So when you sign this agreement, a trust agreement, what you've done is you've created this fictitious entity. Okay, so now there's this person in between me and Dario called your trust. And so you've executed the trust, you've paid probably very good money for the trust. It's in a nice leather-bound trust binder with all of your estate planning documents, and you feel like you did your planning, you did it well. Then what happens is you have to actually transfer ownership of your assets out of your name and put them in your trust. So I see a shockingly high number of unfunded trusts that are a decade old, that have never been funded. So then they come back to see me to update their will, and I look at their binder, and then I look at their deed, and I say, well, your house isn't in your trust. Let me take a look at your bank statements. Well, those aren't in your trust. So now you have an empty $5,000 trust that you never funded. So when you die, all of your assets are still gonna go through probate, and then they're gonna get dumped over into your trust. So to make a trust effective, to avoid probate, you have to put your assets into the trust. You can't leave them in your name. If they're left in your name, they're going through probate. So that's the whole idea of a trust, is to create this fictitious person. This person doesn't have a date of death. It's a document. That's why it avoids probate. So you put all your money, all of your assets, your house, you designate the beneficiary maybe on your retirement, maybe on your life insurance. All of this money is gonna get controlled by this trust. So you own nothing. It's owned by your trust. That's how a trust avoids probate. Oftentimes in a revocable living trust, you wear all three hats. So you are the grantor, or sometimes called the settlor. You're the person that created the trust. You will probably also be the initial trustee, so you will continue to manage the money in that trust. And you are probably your own beneficiary. So you are going to manage the money in this trust for your benefit. And you can change it at any time. That's what makes it revocable. Okay, you could terminate the whole thing if you wanted to. You could change it at any point in time. So because now you own nothing and it's all owned by your trust, when you die, there's no probate, and the transfer of assets happens under Section 4 of your trust that says upon the death of the grantor. And then it says everything goes to your children or whatever you might choose. So reasons that a living trust are good, as I said, because it may avoid probate if you do the work. So it really takes a considerable amount of work on the front end to establish your trust, fund your trust, pay to have a new deed prepared to put your house in the trust. You really have to do the legwork. You're saving the beneficiaries the legwork on the back end. You're going to do all that work up front. If you do the work, it does simplify the transfer of those assets. It doesn't have to go through probate. Nothing gets reported to the Register of Wills. And therefore, it's all private. So that's another appealing factor about a revocable living trust, because there are no probate documents that get filed with the court. So nobody can go look up an inventory of your assets at your date of death. Everything is administered privately under the trust. And you might be able to incorporate some provisions that give you some more control over the assets in those trusts after your death. So if you have, a good example would be if you have a special needs child, if you have a child maybe who isn't special needs but is a spendthrift, or has just never been responsible with money, or God forbid they have, addiction or substance abuse problems, you might want to have a lot of control over how that money can be used for that child over the course of their lifetime. So one thing I tell my clients, it's important to remember the only way to control money from the grave is with a trust. Okay? And sometimes a trust is part of the will, so it's not always a standalone revocable trust type of document. But if you want to have control over how and when money can be used, it has to be done in the form of a trust. Yes?
If you transfer assets, you're also transferring liabilities.
give me the question is, if you're transferring the asset, are you also transferring the liability? Like a mortgage? No, mortgage stays in your name. The debts all stay in your name. You can't transfer the liability of the debt. You're transferring the assets, but really one of the points, which I think is on the next slide, is it doesn't create any separation between you and your liabilities. So like Medicaid, the IRS, your creditors, all of the money in a revocable living trust, still, they see right through the trust. Because you have unrestricted control over that money, they don't really see any legal separation. So your creditors could still reach the money within your revocable living trust, as could Medicaid, as could the IRS.
Yeah, good question.
Yes?
You put money into that trust, right? Do you put assets like realty into the house?
Yes, you can put a house in the trust. You would want to, if you've done that type of estate plan, you would do a deed where you transfer ownership out of your names together into the name of the trust. You can assign all of your tangible personal property, your stuff, your belongings, all of that can go into your trust.
So we have a house, we have 5 children. So when the names are in the will, that goes to equal parts to the children, we avoid probate, right? Is that
No.
That's what I thought, that there is a way to avoid the probate at that time. You don't have to put it in a trust, you don't have to do this. That's what I think when we started out in the beginning.
Yes. A will does not avoid probate. A will only controls the assets that come into probate. So for your house, we keep talking about the house. So when the first spouse dies, the surviving spouse, I'm assuming that both names are on your deed. Okay, so when one spouse dies, the surviving spouse is the sole owner of that house. Now when the second spouse dies, they're the last standing owner. Unless you change your deed, there's no beneficiary named on your house. There's no child named as a joint owner on the house. It's just left in the name of the second spouse. So then it has to go through probate. So the house, maybe the child that you name as the executor decides, all right guys, I guess we're gonna sell mom and dad's house, so we have to clean it out, we put it on the market, we hire a realtor, we go to settlement, now we get the cash, now the cash gets divided equally 5 ways. And all of that happens under the supervision of the probate court or the Register of Wills office. So it still goes through probate. If you wanted that same thing to happen outside of probate, a trust would be one way to do that. So you would create a trust and then you transfer ownership of the house into the trust. So then you don't own anything, the trust owns it. And then when the second spouse dies, the trust says upon the death of the second spouse, ownership passes automatically to the 5 kids. Yes? Yes.
If you put a house in a situation she's done in a revocable trust, you might not want to answer this question, but because I'm curious about the difference in cost.
Sure.
How much would it cost to go through probate? You know, with that house?
Very good question.
How much would it cost to put it in a trust?
That's a great question.
That's a
Did
really
anybody
good
pick
question.
up, I'll tell you the actual answer, that blue book. Can I see that blue book? I didn't grab one from out there. Yeah, if I can take a look at that, I might be able to tell you. So this is comes from the Register of Wills office in Howard County. And so there's a cost. So if you pay to have a full trust estate plan drafted by any attorney, I'm gonna say your fees are gonna range for a couple between $3,000 to $5,000, $6,000, $7,000 to have all of those documents prepared, to have a deed prepared. It will be several $1,000s, and then all of the work that you have to retitle all of your accounts. To compare that to the cost of what if you just let it all go through probate and you have a will, well, there are probate fees, which are dependent on the size of the estate, and I'd be surprised if they're not in here. What is it, 24? There's a schedule in this book that tells you that based on the size of the estate, how am I missing 24? Page 24? Ah, mine's 26. Here we go. Okay, so this is the fee schedule. So for a lot of people, you know, your house is a couple $100,000, maybe you have a couple $100,000 in other assets. So I don't know, if your estate is between $500,000 and $750,000, then the probate fee is $750. So it's nominal. To answer the question in a sentence, the cost of probate is nominal. Yeah.
So, suppose kids decide they don't want to do this themselves,
Mm-hmm.
they go with you.
Yep.
So you would charge something beyond that 750.
Sure. So if you hire an attorney to help you with the probate process, some charge a flat fee, some will charge hourly, but when an attorney does probate, we're taking over the job of the personal representative. So by law, your executor is already entitled to compensation from your estate, and the compensation is 9% of the first $20,000 of your estate and 3.6% of the balance over $20,000. Whatever that works out to be, that's the maximum allowable commission in the estate. So if I do all of the work that your executor would have done because they don't want to do it, my fees are limited to the same, they cannot exceed that maximum, and they have to be approved by the court. Yeah. So it's a couple $1,000s usually, you know, but I mean, that gets a little tricky to say what the issues are in the probate, whether it would be more or less than having done a revocable trust. Yeah. Because there's still trust administration work to do upon your death. So it's not that there's no cost. A lot of time, if you have a perfectly prepared trust plan, everything was in your trust when you died, your kids might still come to me and say, now what? How do we administer this trust?
So let me add, just kind of give you an example of how, because Shannon does a great job of walking clients through that, which is why we have a lot of trust in her. Where we start with clients is what is your goal? You know, what are you trying to accomplish, right? Is it to leave the house to the kids? And what we often see is that the kids, as soon as you pass away, guess what? They don't see eye to eye. They don't. You raised them. You know how they grew up, right? My two boys would fight each other, right? And they'd say, well, no, Dad wanted us to do this. So our family, speaking to me specifically, has used a revocable trust, and our assets are in a revocable trust. My wife has half in hers, and my half is in mine. Because what I'm worried about, my goal is I worked very, very hard to be where I'm at today, and I saved a lot of money. Well, guess what? I don't want some guy to come along and take advantage of my wife. So my money is going to sit in a revocable trust until my boys are older, until they reach a certain age. That's my goal, because I'm going to tell you what, I grew up with a single mother, and I didn't want, and I thought about my mom, if some guy came along and took advantage of her, well, they could take money. There's people out there that will do that. So I think when you understand what your goals are, you go out here and then you back into it, right? Back into...
You reverse engineer your estate.
Yeah, you back into it and you say, this is what we're trying to accomplish. Share that with your financial advisor. Then go to an attorney and say, here's what we'd like to do. And last but not least, is how many of you have had the conversation with your children as to what you want to have happen? Okay? My son wouldn't understand today, right? But when he turns a certain age, he's going to know, and he's in the room, he's going to know what to do. He might be the trustee in the future. So I would have a family meeting. And the family meeting would be like, hey, this is what's going to happen. Let me be very clear. And then you have Shannon reinforce it. Okay?
I have a question. Trust my parents. So they're the grandparents, originally the beneficiaries. And my father died. Then my mother resigned from being the trustee. I became the trustee. She lives in Ohio. The trust is written, it says it's governed by the laws of Ohio. I live in Maryland.
Yeah, so that's when you definitely need to get a CPA involved. And I think that's the part that comes with it. There's a lot of different moving parts, right? We don't think about these things. So that's a great question, is when that happens, you're going to file taxes, and then the CPA will work with you on what your taxes are. But yes, those are some of the, there's no right answer either. There's always a plus and minus.
There's a decision to be made
Yeah.
about how the income on a trust is taxed, and you're right that typically it's taxed at a higher bracket under the trust as an entity than it is under the individual's name. So just to pretend like all of that was going on in Maryland, there would be a decision about whether the trust will pay the tax at the tax level, or if it makes more sense to flow that income through to the beneficiaries using a Schedule K-1. And just like a 1099, that would just be additional income that would be filed and allocated or apportioned among the beneficiaries. So if you were a 90% beneficiary, your sister's a 10%, you would get a K-1 showing 90% of the income from the trust flowing through, if it makes sense to tax it at your bracket instead of at the trust bracket. I don't know the answer to whether or not you will pay Ohio income tax on the income from that trust. I don't know the answer to that. No, the taxes would be the same throughout every county in the state of Maryland. The fees would be the same at the Register of Wills office. They're supposed to not have local rules. There's a rule within the Maryland rules that says there are no local rules. There are local rules in every county. They all do things differently, but the fees and the costs and the taxes are the same. Yes?
What about taxes that you pay down if you're a senior? There's something in Howard County called homesteading.
Property tax.
If you put your property in a local trust, would you then not be eligible? Probably not be eligible.
I believe you preserve that homestead tax credit if it's your revocable trust. Like I said before, I'm kind of talking about one out of a million types of trusts today, but your standard revocable living trust, I think that tax credit is preserved to transfer the property. It's exempt from transfer and recordation taxes, because again, it's really just it's like a trick. It's just a legal trick. It's still yours for all intents and purposes, and that's why everybody still treats it as yours for tax credit purposes, IRS purposes. For your mom's revocable trust, as long as she's alive, that income is all reportable under her social security number. That trust doesn't even have a separate tax ID number right now. And so that's why I was saying before that a revocable living trust doesn't offer you any asset protection from the IRS. It's all taxed under the same social security number. So when the original grantor dies is usually when there's that first separation and a new tax ID number is established at that point.
Yeah. Good
Those are
question.
good questions. Let's see what else we have. So I think we've covered the reasons trusts are good.
Yeah.
Some of the reasons that trusts can be bad or maybe fall short, I think I've also touched on all of these. They are more expensive initially, so you have to be prepared to pay a higher fee for those types of documents. They're much more complicated and more involved. There's more work initially for you to get all of your assets transferred, retitled in the name of your trust. I've mentioned several times it does not protect against Medicaid. So all of the money that you put into a revocable trust, if you or your spouse need to apply for Medicaid in the nursing home, all of those assets are treated as if they belong to you individually. They still have to be spent down in order to qualify for Medicaid. And because of that unrestricted access to the money, it's all taxed as if it belonged to you at the time of your death. So estate tax issues are becoming less and less of a discussion. I mean, the Maryland limit is $5 million per person. The federal limit is over $11 million per person. So at least in my practice, I'm seeing fewer and fewer clients that have genuine estate tax issues right now. But if you were trying to separate out your estate to avoid estate taxes, a revocable living trust is not the way to do that. That's not going to effectively avoid estate tax.
Did you want to touch on, and also sometimes folks own property in different states.
That is a good point. So in addition to avoiding probate, another good reason to use a revocable living trust is if you have multiple pieces of real property. So if you have a hunting cabin in West Virginia and you have a condo down in North Carolina, and you live here in Maryland, that might be a good reason to have a revocable trust. Otherwise, your family will have 3 different probate processes to go through. So they will open your primary probate in the state of Maryland where you reside at the time of your death, and then you have to open what they call ancillary probate in each state where you own other property. So that can be a headache. You know, again, it's all done. It's just a matter of paperwork. Nobody really has to go anywhere, but it's something that could be avoided if you use a trust, because then you're going to transfer ownership to the trust. So now the trust doesn't die, and when you die, you don't have to open probate in 3 different jurisdictions. Yes? Ooh, that's a good question.
That's a really good
I
question.
don't know the
yeah.
answer to that.
I haven't really, we have some clients who own property in Puerto Rico and other, which are, part of the United States. So I couldn't answer that question whether or not.
I don't think I've been involved in an estate plan where somebody owns property outside of the country. I have some that are in Puerto Rico, but
Yeah.
not outside of the U.S.
Yeah.
I've dealt with an issue with a decedent who kind of split his time between Maryland and Greece. And so we had to wait for the Greek probate process to be completed, then the will to be translated, and then to have a probate here in Maryland. That took a long time, but I just don't know the answer off the top of my head.
Yeah, and I think also too, some folks who own property or in Canada and assets there, they have different laws that will, have to have a probate there. So that's a really good question.
Yes?
Can you talk a little bit about owning a home and the Medicaid spend amount? You said the home becomes part of the trust. What if there is no trust? How does the home do as far as Medicaid and assets?
Okay, that's a great question. The question is, can I talk a little bit about the home and Medicaid and how that works? And it's a great question. I'm going to try to keep the answer as simple as possible. It's probably my fault, because I have a tendency to throw this word Medicaid throughout these presentations, and it's only because so much of my practice is focused on Medicaid, but it's kind of a topic in and of itself. Here's the best way I can describe it. So when you apply for Medicaid, you have to spend down your assets. Whether you're an individual or a married applicant, the asset limit is very different. An individual applicant can have no more than $2,500 in his or her name. A married applicant could have up to a maximum of $126,000, but never has to spend down to less than, I forget what the 2019 number is, $24,000, $25,000 and change. So your house doesn't count as part of that asset limit. So as long as it is the Medicaid applicant's principal residence, immediately before they go into a nursing home to apply for Medicaid, the house is exempt. It's not a countable asset toward those limits. But that's only the first part of the process. So that's great that you don't have to spend down your house. But then on the back end, if you spend down all of your other assets and now you're on Medicaid, you still own this house. And if it's just in the individual's name, it's hanging out here in the wind waiting for Medicaid to file a lien against it. So that's how it works when you own real property and you're on Medicaid. They're basically just advancing the cost to the nursing home because they know you can't pay the nursing home with your house. But they're going to file a lien against that house, and when the applicant dies, they will recover all of the money they have paid out for that person's benefit. So when we have a married applicant, one of the steps is to remove the nursing home spouse's name from the house and keep it in the name of the community spouse. That's step one. And we can do that type of transfer without any penalty because you can move assets between spouses without penalty. Then once we get Medicaid benefits in place, we do a second deed. Somebody back here had been asking about, we were talking about a beneficiary type of deed. It's a life estate deed. So we would then do a second deed where we add beneficiaries to the house so that if the community spouse dies first, that house stays outside of probate. It defeats the Medicaid lien. It defeats the Medicaid recovery process against the estate. So, and interestingly, the Medicaid rules say, even if we're talking about a principal residence, if you have a revocable trust and if you had transferred your house to the revocable trust, then Medicaid will treat the house at its full fair market value if it's titled in a trust. So if people come in, the house is in the trust because that met the requirements of their old estate plan, we have to take the house out of the trust, put it back in the name of the spouses individually, apply for Medicaid, and then do the transfers. So it's complicated, but there are issues that can be solved. It just depends on the circumstances. Yeah.
I kind of looked into this with my mother
Mm-hmm.
when that's the case. I was not aware. I was always aware that Medicaid spend down
Mm-hmm.
and how many years they looked back. I wasn't aware that there's an income limit. If your Social Security and pension is above, I believe, $1,500 a month. What is the limit now?
No, so the income test is actually as long as the applicant's income is less than the private pay cost of care in the nursing home, then they pass the income test. So usually most people pass the income test unless they have 9, 10, we're talking about nursing home Medicaid, long-term care.
The long-term care place she went to said she wouldn't qualify for Medicaid because she had, it was over 2,000
The $2,500 number is the asset number. So the income only has to be less than the private pay cost of care. The assets have to get spent down to below $2,500 at the first day of the month that we're going to apply, but then the person gets their income. So you're at $2,500 on day one, you get $3,000 in income. So on the 15th of the month, you're at $5,500. But then you turn around and it's calculated for all of that money to be spent back down by the end of the month on health insurance premiums, personal needs allowances, nursing home payment, and you're back down. So if you look at the bank account balance on a Medicaid recipient's on a chart, it's always going to start here. Well, I guess from your side, it's going to start here, go up, and then it all comes right back out by the end of the month. So that's the interplay between the income and assets. But for long-term care benefits, for the last 12 years, it's been as long as it's less than the private pay cost of care. If you were trying to have her discharged back home on the waiver, see, there's other Medicaid programs that it could be different income limits.
Yeah, it's a lot.
Always remember this, and nursing homes are a wonderful service for people that need the services that they provide, but they are not working in your financial best interest. In fact, there's a diametric conflict of interest there.
Yeah.
So you just can't, I'm not trying to paint them in a bad light, but you can't take financial advice from the nursing home. Their idea of a spend down is you pay me all your money, and then when you have none left, we'll help you fill out the application to file for Medicaid, knowing that there are many other ways that those resources could be utilized.
Yeah. I think that's a great point. And again, you have to know your long-term care plan when you think about it, and that's what we work with clients through. Where is the first place we're going to go to? Are you open to, and I think that's what's great about Shannon and I, is I have a different opinion, you know, in some cases where I have a different view. I think if you've saved your hard-earned money, you know, and you want to protect your spouse, you pay for it. But if you have a plan, at least we know we can go to Shannon, and Shannon is going to not only do their estate plan, but she'll also help them with Medicaid and how she does that. So back into it, you know, how are you going to do it?
Yes.
It seems as if you're suggesting that long-term care insurance would be a good thing to have.
Well,
I think we agree on this.
yeah, I think we agree, definitely. I do. And the firm, you know, definitely agrees. And there's a conflict of interest there, too, because we have insurance products, right? And the insurance products that we use are traditional long-term care. And then there's some other newer products out there that are available to clients. But yes, I do think that they are important, and I think that's part of a plan, absolutely.
My only qualm with long-term care insurance is that people misunderstand many times what it's going to do for them.
Yeah.
So I don't want you to go out and buy a long-term care insurance policy with the idea that now you will never need to apply for Medicaid. In many, many, if not most cases, your daily benefit under a great long-term care insurance policy is not going to be enough to cover the full daily rate in a nursing home. If you're lucky, your income will cover the difference. If you're not, then you're still basically in a spend-down mode where you're paying from your assets to cover that difference anyway. The best thing about long-term care insurance is it might prevent you from ever having to go to the nursing home.
Yeah.
So if you have to be in the nursing home, in many cases it's not going to be enough to cover it. So I have plenty of clients that I've helped apply for Medicaid that have long-term care insurance policies. The difference maker is the people that don't have any other choice. Maybe they're not really medically appropriate yet for a nursing home, but they don't have money to pay privately. They can't bring caregivers into their home. They would love to have to go to an assisted living if that was the worst case scenario, but they can't pay for it. So we basically have to push the envelope and get them medically certified to be in the nursing home just so we can access Medicaid benefits, because they're hamstrung. They have no other way to pay for it. So that's the benefit in my mind for long-term care insurance, not that it pays for the nursing home.
Yeah. Good question.
Yeah, great question. Anything else? Yeah.
Is there some kind of rule of thumb about what your assets are worth before you decide to go into a trust? I mean, if a will cover most of what you need, should you spend the money on a trust only if your assets exceed $1 million, $2 million? Is there a rule of thumb?
My advice or opinion would be, if you're comfortable as a couple, if you're comfortably below those estate tax limits, you know, my normal bag of tricks of trust that we would use wouldn't be necessary. Not for a financial benefit. So you still might want to have a trust for all of those other things we talked about, but it wouldn't benefit you financially in any way. When the estate tax limits were lower, before we began this phase up to $5 million, Maryland was at $1 million for a long time. And the federal limit continued to increase. And so we said, all right, we're going to finally phase up and match the federal limit. That was before the current president said, we're going to bump that up to 11 million. That's when last year Maryland pumped the brakes and said, we're not on board for 11 million per person. So we were at $1 million. So even people that don't feel like millionaires, by the time you put your house and maybe your retirement account on a piece of paper, you might have had a taxable estate. So in those cases, we had to use trusts within the will, bypass trusts, disclaimer, to try to separate out your estate so that the surviving spouse wasn't left holding the whole bag and subject to tax. So we would use those types of trusts. Life insurance trust would be another type of trust if you had a taxable estate. Some people say, well, I don't want my estate to bear the brunt of that tax bill, so I'm going to create this irrevocable life insurance trust. We're going to purchase a whole life policy. It's going to build up cash value, and when I die, it's going to pay out, and that money is going to be used to cover the tax bill instead of my assets.
So what would you say the Maryland state tax limit is?
Currently $5 million per person.
Yeah.
And that's for the foreseeable future. I don't see that going back down. It took us a long time to get up to that point, and I think it's adjusted periodically for inflation.
It is. Yeah.
Or annually even. And I think the consensus among professionals is that when the administration changes at the federal level, that it will probably be adjusted back down. We don't expect the federal limit to stay at $1 million and upwards from this point forward.
Yeah, and again, I think it's all customized to what you want. What are your goals? And so sometimes we have children who, like you said earlier, are spendthrifts, or you just don't want to put your children through that probate process, because sometimes a kid will need the money right away, and they want it, and then they start to become a squeaky wheel, and things go along faster, so sometimes that allows for liquidity.
Right, so it can be a question of what number you're comfortable with. Some people just feel like they have too much money to just pass this outright to their children without any requirements. Well, if we want to put requirements on it, then we would need a trust to do that.
We're comfortable with $5 million.
Yeah.
Yeah. Yeah. Yeah.
Any other questions? That's a lot of information. I mean, you guys asked
Yeah.
you asked good questions, and so we went off on a couple tangents here, but Dario and I had presented this topic before to a retirement community, and like we said in the beginning, it's a question that we hear a lot. People are not even really sure, like you were asking, well then why do I have a will? So I wanted to be sure you understand what probate is, what your will controls and what it doesn't control, the importance of revisiting and updating your beneficiary designations, and ways that you can avoid probate, whether that's through a trust, through beneficiary designation, joint ownership with the spouse. Remember POA, POD with your kids, not joint ownership. Anything else that you have?
Yeah, no, I thank you for allowing us to speak to you today. It's a pleasure, and I think the more we can do this and the more you share with folks, you know, what their options are. I've left you with 2 pieces that can help guide you when you go home and you're talking amongst yourselves. But I think from a financial advisor or as a planner, one thing I think is important is the family meeting. It never hurts to do that. You know, it's going to happen anyways, but you might as well share that if you feel comfortable doing that. And that happens over multiple appointments. It just doesn't happen right away. So I think working through that helps them understand what that picture is and how that works. The other thing is the living will, power of attorney. Those powers are important to have in some cases where you're trying to take care of financial affairs. We can't do anything sometimes when somebody becomes incapacitated, right? So you have all your wits with you, and the next thing you know, like my grandmother who's 95 years old, she's losing her memory, and she never thought that was the case, but she is. And so my aunt is the financial power of attorney, but if she does not have that power, she can't make decisions for her. So I think that's important. And then last but not least, walk through the changes in your lives. You know, walk through that, share that. Don't be afraid to ask for help, right? Yeah.
That's a question I've just been thinking of.
Yeah.
We did wills maybe 10 years ago and thought we had our questions pretty much answered. We also have a financial, what do you call him, financial guy who,
Yeah.
a company
Yeah.
that takes care of our investments, that kind of thing.
Yep.
Where do those two things come together and how often should we, in other words, I'm thinking we have a gap between a 10-year-old will and a current financial planner. A person like you, that may be our original lawyer, but now
We are those two people. He
Yeah.
is the planner and I am the lawyer. And so the best results happen when we're sharing a client and I'm in his office to do the document signing and we say, and I'm not saying it has to be me or it has to be him.
Yeah.
Whenever those two professionals come together, then you're making sure that what I'm drafting for you is consistent with what he's got on your beneficiary designations and vice versa. So you could absolutely ask for those people to have a meeting with you together. Schedule an appointment with your attorney and invite the financial advisor to come with you to make sure that they're all on the same page.
Yeah. I think that's really important. If they're not asking those questions, they should be.
Well, yeah, I sort of get the feeling from the financial guy that that's out of his, we haven't really talked to him about this specifically, but
Yeah.
they're more interested in how do you want me to invest in this?
Will you speak to that? That's important
Yeah,
for
no,
people to understand the difference.
I think it is important.
Yeah.
So,
She's
yeah,
saying that
question.
she's got a finance guy that's more worried about where to invest the money than he is about sort of a holistic plan involving the attorney and making sure.
Not even asking the right question.
Well, it might not have even been your responsibility to ask the
Yeah.
question.
I do think it's important. So the question, you know, you stated the question, which is
Yeah.
how often should you be reviewing things? And quite frankly, at a minimum, from a fiduciary standpoint, once a year.
But I want you to talk to them
Yeah.
about the difference between money managers, people that invest your money versus planners, and what the difference is in terms of what they're getting.
Yeah,
the
so
service.
it's hard because you don't ever want to knock another professional. So I think as you ask for help, the one thing is that they should be going over your goals, and that goal is, okay, what is this money for? You know, why are you saving it? So how many of you wanted to get to retirement? I still want to, right? Right? Maybe some of you are still working. You know, I never judge a book by its cover. But, you know, the goal is retirement. And that's the first thing that pops up into our financial planning. The second thing is, well, if something happens to you, that's our question, where does it go? Why am I working for this money to help you get to retirement, but if something happens to you, where does it go? So that should be the second question. Then, how is it going to get to that person? What do you want it to do? Well, I would like this money over here to go to my grandson. And you specifically state that. Well, then I know on my checklist that money is designated for her grandson. And you've told me that, and then we take those dollars and we put it there, right? And we can do that through a simple account by literally opening another account, putting a TOD on it, and guess what? It goes to your grandson. Does that make sense? Okay. The other thing is that every 3 years you should be reviewing your will and your big picture. You know, where is this going? So to answer that question directly, I'm then listening to you hearing what you have to say, and then you tell me out of the blue, I call you up and I say, hey, how's your son Mark doing? And you're like, oh, we can't find him. And I'm like, well, what happened to him? We don't know. And he left his wife, and we're like, okay, right? So it's time to come in, let's talk. So once that happens, I then get on the phone with Shannon, and I say, hey, listen, here's the deal. And it might just be a quick codicil, and I shouldn't probably say that word because I'm not an attorney, but she could do that for you. Yeah, and then she will basically change your will. The other thing that happens is the one thing that scares me is the incapacity. That scares me because I've listened to most of our clients for the past 12 years tell me what their dreams are, what their goals are, and then all of a sudden somebody comes into my office and wipes it all out. And that's what stinks. So if I'm not clear on what your goals and your dreams are, the money is just a vehicle to help you get to your goals. So then with working with Shannon and your CPA, you should do that meeting every once a year. It should be once a year with your CPA, at least, of course, because you're meeting with them. Okay, does that make sense? Hopefully, yeah.
You talked a lot about TOBs for bank accounts. Is there anything outside of setting up a trust to transfer private money real estate property like that?
A deed, there are certain types of deeds that can do that. You just want to be very careful and talk to somebody about the various options because they have different tax consequences for your kids, capital gains tax consequences, more technical tax issues about basis and stepped up basis, carryover basis. Adding your children as joint owners on your house is very different than designating them as remaindermen, like beneficiaries. They have completely different tax consequences, and the extent of control that you're willing to give up over your property while you're alive. There are all sorts of decisions to make there about that. So the answer is yes. It's just a question of which option is best for you.
Yeah. As far as changing the beneficiary, about the deed, no, she would handle that. But most of the time, I think we had a recent client who did that. They wanted to change that, and then I just direct them to Shannon. Mm-hmm. Yeah. And from a fiduciary standpoint, for me as well, I have to always refer to attorneys and to CPAs so that you get an objective opinion, right? So, and also who you feel comfortable working with. So Shannon is at the top of the list for that.
Yes.
So it would be beneficial if you had a financial planner come with you as we make an appointment for future.
It's a good idea. They don't have to necessarily come with you, you know, in some way communicating with the attorney. There should be an open line of communication there. When somebody's referred to me by a financial advisor, I normally ask that we can put that advisor's name on my engagement agreement as an exception to the rule of confidentiality. So that will allow me to disclose and discuss freely the plan with the advisor, just like I can discuss it with you in the office. And the point, I think, and to your question and also to yours, what I really wanted you to drive home is there are differences. You know, all of these letters that come after Dario's name, those all mean different things. And there are some people who are just money managers and are more worried, like you said, about where you invest your money. There are some people that are planners and that are going to take all of those other pieces into account. And I think that's the difference, maybe. So, you know, the financial planners that I work with, it's, you know, I sit in their office, we go over the numbers with the client together. So it's not an unusual thing.
Yeah. And last but not least, something that is very sensitive these days too is fees, right? So fees, you know, how you're compensating your advisor, right? I think that's important. So if you're just getting money management, that is a certain fee, right? So how are they bringing value? And the value is where they should be having those conversations with you because you're compensating them. So as you're compensating this advisor, they should be having multiple meetings with you dependent upon what you want. So if you want to meet quarterly, they should be there to meet with you quarterly. If it's semi-annually, they should be meeting with you semi-annually. The other thing that we do that's something that's different, somebody asked about paying bills. Somebody was questioning about paying, I think it was maybe you, about paying bills. Our trust company It doesn't have to be in a trust, but we have a trust company who is a corporate entity that has to pay your bills. So that is a service that is provided to some of our clients to help pay their expenses just in case that ever happens for some folks.
Thank you. We covered a lot of ground, so
Yeah.
if you think of things later on, I'm
Good job.
sure I probably speak for Dario. Feel free to reach out to
Yeah.
either one of us with questions. My contact information is on the top of the printed materials and also on the back of that folder, so send me an email or call my office, and I'm happy to answer questions that you think of later on or point you in the right direction, make a referral if you need one,
need
whatever the
it,
case
right.
is, and I'm sure that Dario feels the same way.
Yeah.
Thank you very much again for having us.
Yeah,
It was
thank
good
you.
to see you again.
Thank you.
And I want to say thank you to our speakers. As usual, we have not been disappointed. For those who've been coming for the last 3 years, Shannon is probably one of our most popular speakers. Everyone knows they're going to get a wealth of information, and it was wonderful to have Dario with us today, too. So that added another perspective, and thank you both so much. Okay. In the absence of Father Jerry, I went to the internet for an appropriate prayer because this is the third year for the Gift of Peace ministry, and it's we've pretty much each year we look at feedback we receive from attendees. We look at attendance. We look at our speakers. We look at a lot of things, and this is the time of year where we sit back and say, do we do the same thing next year? Do we have to change something? Our feedback has always been positive. And this last year, we actually got some suggestions for some other things to do. So what we are discovering is at the workshops, if any of you have attended our workshops, those are very personal, they're conversational, and the response has been wonderful. The people who attend them are usually people in the more senior age group, because heaven forbid if anybody else would have those conversations with their family because they're too young to worry about death. They'll have the conversation with their parents, but they don't have the conversation among themselves. We haven't been successful at reaching the under 50 age group. Very few, unless they're coming with their parents. Everybody should be having the conversation about end of life. Everyone should have someone who is designated as a health agent and who can make decisions for themselves when they can't speak for themselves. The other extreme are the parents who sit with their teenage children at the table and think those children can make a decision, and a lot of times a 13-year-old is not going to want to make that decision. But people don't think of it. They think of preparing financially, but they don't think of preparing medically. And so this year we're looking at how do we reach that next group. We've looked at other options, and so on June 13th, we're having a meeting. If you've attended before and we have your email address, you got a request for help for next year. And what we're primarily looking for is people to come to the meeting and listen to our ideas and tell us if they think they're really good ideas, because we have ideas for 2 really ambitious events next year instead of 5 or 6 events or 8 events like we've been holding. We're also looking at creating a video of the conversation workshop so that families can take it home and have the conversation with a 2-hour video, and one of us going with them with the video to help, or just using a video in your family to have the conversation. That's going to take some work to get that video put together this summer. So we're looking at a lot of things. So anybody who's interested in coming to that June 13th meeting and helping with the planning for next year and listening to our other ideas, please see me afterwards or send me an email, or my phone number is, actually it's not under Gift of Peace. My email's under Gift of Peace in the newsletter. My phone number's under Pastoral Council, the last name at the bottom. So I hope that you will consider providing your opinion. And if these two events come off next year, we're going to be looking for some bodies to help us pull them off. So with that, I want to thank everybody at the end of this program year, and I want to thank my team. The ministry team's been fantastic. We have people who show up here for all the events and help us lug this stuff in and clean stuff up. And we have people who sit at our meetings and work with the conversation workshops and things like that. And it's a team effort, and so we've been very blessed. And we've been very blessed with our feedback. So my prayer that I looked up, I miss Father Jerry because he always has the appropriate prayer, and it's less work for me. It's called a prayer for wisdom. Dear Father, your wisdom is above all, and today we praise you for being the all-wise God. Though our mind is incapable of understanding all your ways, we trust that you keep every one of your promises. You are good, and you make all things for our good. While we know this is true, we often fail to be wise in applying this truth. Help us, Father. We need you. We need the heavenly wisdom that can only come from you. Give us the strength to pursue. Give us the power to practice. And we'll praise your name. Amen. So that's for wisdom as we come through this decision process for next year. Thank you all.